Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. Continuing with our endeavor to study the important judicial pronouncements under the Insolvency and Bankruptcy Code 2016, which is now reshaping the economic landscape in our country, I bring you today yet another important landmark judgment under the Act IBC. So friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into such important judicial pronouncements under the IBC 2016 and also navigate through the intricacies of such proceedings. So today, let us discuss the case of SHIV CHARAN and others versus Adjudicating Authority, which was decided on the 1st of March 2024 by the Honorable High Court of Bombay. Now, in the case of SHIV CHARAN and others versus the Adjudicating Authority and another, the division bench of the Honorable High Court of Bombay, inter alia, upheld the powers of the Honorable NCLT Mumbai to direct the Enforcement Directorate, which is the ED, to release attached properties of a corporate debtor after the approval of a resolution plan by the NCLT in light of Section 32A of the Insolvency and Bankruptcy Code 2016. Let us see the factual background of the case. Various FIRs were filed against DSK Southern Projects Private Limited, which is the corporate debtor, and its erstwhile promoters in October 2017, alleging cheating and criminal breach of trust, which were scheduled offense under the Prevention of Money Laundering Act 2002, that is the PMLA. Accordingly, in March 2018, the Directorate of Enforcement, the ED, filed an Enforcement Case Information Report, that is ECIR, and pursuant to the ECIR, the ED attached certain assets of the corporate debtor by way of a provisional attachment. The provisional attachment was continued by the Adjudicating Authority under the PMLA via its confirmatory order dated August 5, 2019. Subsequently, CIRP was initiated against the corporate debtor at the instance of a financial creditor. The Honorable NCLT, via its order dated February 17, 2023, approved a resolution plan by Mr. SHIV CHARAN and directed ED to release the attached properties of the corporate debtor. By way of a subsequent order dated April 28, 2023, NCLT yet again directed ED to release the attached properties. However, the provisional attachment continued even after the commencement of CIRP of the corporate debtor and further continued after approval of the resolution plan. The resolution applicants filed a writ petition inter alia seeking directions to release the attached properties in the light of the approval order. A counter writ was filed by ED challenging the validity of the April 2023 order passed by the Honorable NCLT. Now let us see what were the issues before the High Court. The Honorable High Court identified the core issues that arose for its consideration. First, can an attachment by the ED over the assets of a corporate debtor continue after the approval of the resolution plan? That is the issue of release of ED's attachment. And secondly, does the NCLT have the jurisdiction under Section 60, subsection 5 of the IBC to direct the ED to release its attachment over the assets of a corporate debtor, invoking Section 32A of the IBC? That is the issue of NCLT's jurisdiction. Let us see the findings and the rationale. The issue of release of ED's attachment. First, we will look into that. Section 32A of the IBC, which provides for immunity to a corporate debtor, applies only after a resolution plan is approved. Section 32A grants immunity to a corporate debtor from liabilities which may be imposed on a corporate director for offenses committed prior to the commencement of CIRP. Such immunity will not be available if the promoters or those in management or control of the corporate debtor or any related party of such persons continue in management or control of the corporate debtor under the approved resolution plan. To qualify for immunity, there must be a clean break with a change in the ownership and control of the corporate debtor. 7. Except the corporate debtor, all other accused shall continue to face prosecution and remain liable for the alleged offences. Now, while enjoying immunity, the corporate debtor is required to cooperate with the investigation. So, Section 32A of the IBC is a non-obstantive provision. Accordingly, Section 32A of the IBC should prevail over the provisions of the PMLA, which is a prior legislation. Now, relying on a decision of the Honorable Supreme Court of India in Manish Kumar, the High Court noted that the immunity from prosecution granted under Section 32A of the IBC reflects Parliament's legislative intent, referring to the clean slate principle under IBC. The Honorable High Court emphasized that upon approval of a resolution plan, the release of attachment over the assets of a corporate debtor should be automatic by operation of law. There is no scope to continue the ED's attachment over the assets of corporate debtor after the approval of a resolution plan. There is no discretion with the ED to decide whether or not the immunity under Section 32A of the IBC can be granted. Since Section 32A of the IBC grants immunity to the corporate debtor against prosecution, there cannot be any conviction of the corporate debtor. Accordingly, the continuation of the attachment by the ED over the assets of a corporate debtor would make no sense in a situation where the corporate debtor cannot be convicted. Now let us see the next issue, that is the issue of NCLT's jurisdiction. Similar to Section 32A of the IBC, Section 60 subsection 5 of the IBC is also a non-obstante provision. Accordingly, Section 60 subsection 5 should prevail over the provisions of the PMLA, which is a prior legislation. Under Section 60 subsection 5 of the IBC, the Honorable NCLT has the jurisdiction to decide any question of fact or law arising in relation to insolvency resolution proceedings. Such questions of facts and law would obviously include issues arising under Section 32A of the IBC. And by giving effect to Section 32A of the IBC, the NCLT does not render the provisions of PMLA nugatory. Under Section 31(1) of the IBC, the NCLT must be satisfied that the provisions of the resolution plan can be effectively implemented. The Honorable NCLT has the power to direct the ED to release the properties from attachment in order to implement the law prescribed under Section 32A of the IBC. So, friends, we conclude that the decision of the Honorable High Court in SHIV CHARAN lays down the law on the status of ED's attachment over the assets of a corporate debtor with an approved resolution plan under the IBC in clear and precise terms. This decision is also supported by the terms of Section 31(1) of the IBC, which prescribes that an order of the NCLT approving a resolution plan is binding on all stakeholders, including the central government, any state government, and local authorities. The Honorable High Court has observed that upon approval of a resolution plan qualifying for immunity under Section 32A of the IBC, the ED's attachment over the assets of the corporate debtor ceases to exist by operation of law. So, friends, we conclude that the Honorable High Court has again protected the interests of the resolution applicant and upheld the principle wherein the clean slate of the corporate debtor will be provided to the resolution applicant so that the corporate debtor gets another chance to live. So, friends, I trust that you find the judgments both engaging as well as enlightening. So for further insights into such key judgments under the IBC, please like this video and subscribe to my YouTube channel. So friends, thank you for being here today with me. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.